We can begin. Good afternoon, ladies and gentlemen. Welcome to CCPL's 2022 first book webinar. And today we have with us the two distinguished authors and the book before us, Abusive Constitutional Borrowing. And we have one discussant who is no stranger to the faculty. So let me begin by introducing our authors. They are Professor Rosalind Dixon, who is a professor of law at University of New South Wales, and Professor David Landau, who is Associate Dean and Professor of Law at Florida State University. And discussing the book is another eminent scholar and author, Professor Stephen Gabam, who is the, Stephen Yezel Endowed Chair in Law and Faculty Director of the Promise Institute for Human Rights at UCLA. Before we allow the authors to share with us their insights, perhaps I'll just quickly sum up the book for all of us. All right. So basically, the authors here have identified this theme for us to consider. And they argue that we see two trends in the world today: an increasingly dense age of constitutional globalization and concurrently a backsliding in democratization around the world. In their view, both trends are fully consistent. And the key link they argue between these two trends is that illiberal states are increasingly engaging in abusive constitutional borrowing. That is, the appropriation of liberal democratic constitutionalism, designs, concepts, doctrines by state leaders, legislatures, and courts to subvert democracy itself. So with that, perhaps I will just pass on the floor to the authors to elaborate and explain their thesis to us.
Thank you very much, Po-Jen, for having us. Dave and I are both very grateful. We'll divide talking about the book. I'll start and then David will take over and give some rich examples of the phenomenon that we have in mind, as well as start to think about what solutions might be. But as you say, first to set the scene. Before I do that, though, I just want to thank you, Po-Jen and Winnie, for putting together this webinar. We're incredibly grateful. Hong Kong University is one of the great global universities, and the CCPL obviously has been a great friend to me personally, as well as to the centre at UNSW that I direct. And so we're delighted to collaborate and join this. And we also want to thank Stephen for his generous reading of the book and engagement with it. And again, someone whose work has been influential on all of us. For those of you who don't know that Po-Jen, David and I were all, within a few years of each other, graduate students at Harvard, and we all thought about in many different ways and jurisdictions the idea of weak form review, and some of the ideas that Stephen developed in his book on the Commonwealth model were extremely influential on all of us. So this is an especially happy, if you like, book reunion of like-minded thinkers, as well as great friends in the field of comparative constitutional law. And we're really grateful to you both, Stephen and Po-Jen, as well as your colleagues, Po-Jen at Hong Kong U, for hosting us. So the book brings together a number of strands of thinking, but as you say, Po-Jen, it really is about two converging trends that we see in the world. The first trend being one that is very familiar to many of those in the audience and of grave concern, which is the erosion of democratic constitutional commitments in some of the world's leading democracies. David wrote a well-known article in 2013 labelling this the problem of abusive constitutionalism. It's a word that has caught people's attention, but others often call this a phenomenon of democratic backsliding, decay, degradation, rot, etc. But the phenomenon of erosion in democratic constitutionalism is clear, and one that is an important part of the motivation for this book. The second intersecting trend is the proliferation of borrowing and transfer of ideas globally. So a form of legal globalization in public and private law. And indeed, the thickening of the comparative constitutional community that we are all part of, and which events such as today's really represent in some important way the manifestation of. So we live in an age of backsliding, but we also live in an age of global interaction in the field of law, and especially public law. And we suggest that the orthodox account has been one in which global public law norms are the defenders of democracy. They are the constraint that serves to restrain or slow down democratic backsliding. And we actually are believers in that account, and we've contributed to that literature. And we don't wish to suggest that global public law has nothing to say to the problem of abusive constitutionalism. Indeed, we do believe it can contribute to what we call abuse proofing, a constitution against the risk of erosion. But there's another important trend that we want to call out, and that we call out in this book, which is the ways in which legal globalization and comparative constitutional law has been used and weaponized by would-be authoritarians as both inspiration and justification for the erosion of democracy. So those of you who are familiar with some of the critical work in international law will be familiar with some of the suggestions by David Kennedy about the dark sides of human rights law. And this book is in many ways the dark sides of comparative constitutional law. It's how global constitutionalism is used and abused by would-be authoritarians to inspire and legitimate anti-democratic constitutional change. That is the overarching claim of the book. And we suggest that the phenomenon is indeed widespread and an important one that is under-noticed as part of the dynamics of our age. We suggest that abusive borrowing, as we call it, takes a number of different forms which can overlap in practice but are worth disaggregating, at least at the level of theory. And those forms are fourfold. First, borrowing that is radically superficial. The second, borrowing that is radically selective. Third, acontextual, or four, anti-purpose in nature. Now, all transfers of ideas have some degree of acontextuality or repurposing. By nature, when ideas move across context, they change. But we think that the kind of decontextualization and repurposing that we notice has a difference of degree and context in terms of impact that makes it meaningfully different and abusive in nature. So that's the four different variants that overlap but are meaningfully different and worth noticing. The second thing that we say is that in noticing these kinds of uses, it is important to have some yardstick for determining what counts as abuse. Abuse is often used colloquially to mean a wide range of practices that we find problematic. But David, in his original work and in subsequent joint work, we have developed an understanding of abuse which is more particularized in terms of the yardstick. And that is one in which we focus on the notion of what we call the democratic minimum core. So democracy is a widely cherished yet fundamentally contested idea. It's one that people have very different understandings of. And one of the things we try and do is to try and stipulate an account of democracy that we think provides a relatively clear benchmark for judgments about abuse, one capable of commanding support from all reasonably minded democratic theorists and adherents, and that draws on the overlap between actual extant practices among constitutional democracies. This does not exhaust what democracy is or requires, but it represents the minimum necessary for a truly functioning constitutional democratic system. And we suggest that that consists in one, multi-party free and fair elections held at regular intervals. Two, political rights and freedoms of at least some minimum degree. And third, a level of checks and balances or independent oversight from institutions capable of maintaining the first and the second. And one of the things we'll obviously be interested to hear from Stephen about is how this intersects with some of his evolving work on comparative political process theory in stipulating what it is about democracy that courts and other institutional actors, including scholars, should be committed to in thinking about what the minimum is for democratic preservation. So that's the second thing that we say in the book, is that not everything is abuse according to our definition. Many things are problematic without necessarily being abusive. Abusive, as we defined it, is action that derogates from or degrades the democratic minimum core as we define it. And then the third thing we say is that abuse could be understood in a strong or a weak sense, and this is not the sense in which the new Commonwealth constitutional model employs the term, but rather just in the sense of clearly abusive or arguably abusive. The strong form is where you can show intent, where you can actually show that the person knowingly or willfully used liberal democratic ideas to degrade the democratic minimum core. The weaker notion is where one can show only impact and a lack of mens rea or intent. In most contexts, we think it's appropriate to focus on the strong form of the phenomenon, so the intentional or knowing misuse of liberal democratic ideas in the service of anti-democratic ends. But in some instances, we think it's more appropriate to take the more capacious or weaker view. And in any event, the two will overlap, because most of the time we won't be able to get at intent directly. We'll be relying on circumstantial evidence about impact in order to infer intent, and or a range of procedural settings that might suggest an indication of knowledge or intent, and that we won't have direct evidence of intent in order to make a definitive judgment about whether there is intent or not. So to recapitulate, abusive borrowing can involve one of four overlapping techniques of decontextual use and adaptation. Secondly, it necessarily involves an adverse impact on the democratic minimum core. But thirdly, it can be weak or strong, meaning knowing or intentional, or simply unintentional and measured by way of impact, depending on for what purpose one's asking the question and answering it. One of the things that we do in the book is to say that this is an under-noticed phenomenon, and indeed one that really does traverse the globe and traverse some of the most important areas of liberal democratic constitutional design and doctrine. And to illustrate that, I'll turn it over to you, David, to just talk about some of the substance of the book before I offer one or two concluding thoughts.
Thanks so much, Roz. And I just also want to give thanks to the Faculty of Law at HKU for inviting us to give the talk, to Po Jin in particular, and to Winnie for coordinating. Also to Stephen for coming to comment on the book on a Sunday night in LA. Thank you for that. I'm just going to talk primarily, about some of the examples we go through in the book. That's sort of the meat of the book in some ways. We set up the theoretical framework, and we go through, I think, a lot of interesting manifestations of the phenomenon kind of in the middle chapters. And they're drawn from four different areas. So we've got four different chapters that kind of go through showing how this works in action. Constitutional rights and constitutional courts, two essentially cornerstones of liberal democracy. I think it's interesting to show how those can be abused or turned into instruments of authoritarianism. Constituent power, which I think in its own way is a sort of cornerstone of liberal democratic theory, although it has a more contestable pedigree. And finally, political constitutionalism, which is kind of a recent, interesting, important example of many of these debates about the different form that liberal constitutionalism should take. And we also draw on different kinds of cases. So some of what we draw on in the book are fairly well studied cases of democratic erosion where we think our analysis sheds new light. This is places like Hungary, Poland, Venezuela, for example, that are kind of on the list of what Ron Herschel has called the usual suspects, right? The countries that get studied for this phenomenon. But a number of others were drawn off, we think, have been much less studied. So places like Cambodia, Fiji, Rwanda, for example, are all places that have gotten less scholarship and yet are really interesting. And there are important things going on there as well. So we try to be kind of plural in terms of region, also in terms of looking at different cases outside of the kind of normal canon. And then I think it's important, Roz mentioned this point, that it can be carried out by a number of different types of actors. So we highlight examples that are kind of legislative and executive, but also a number, of course, that are judicial. So we have a recent article, Abusive Judicial Review, which just kind of highlights the role that courts, unfortunately, can play in a number of these efforts. It kind of borrowers in two sense, right? One is judicial review itself is abused by a regime as an instrument of authoritarianism. And the second level is that courts, unfortunately, under certain conditions, basically after being captured by a regime ordinarily, can adopt doctrines in a way that's essentially abusive, right? So they're one of the more interesting set of cases of the use of liberal democratic ideas for anti-democratic ends. So for the sake of time, I won't go through too many of the examples in depth that we have in the book, but I do want to draw out, a few. So in terms of rights, we look at Rwanda, the way the Kagame regime used both hate speech laws and also gender quotas in Rwanda to basically prop up an authoritarian regime. And so what you see in the Rwandan case is the weaponization of hate speech laws, for example, to target the opposition. Gender quotas is a way to farther buttress the support of partisan actors that were close, basically, to Kagame. And these are really interesting, rich examples, because on many of these, I'll talk about this a little bit when we get to solutions, and Roswell as well, but with many of these, the regime was celebrated internationally for these steps, right? That's particularly true of gender quotas, where Kagame was celebrated in the international community. And yet there seemed to be, to some degree, a blind spot or a deliberate overlooking of the effect that some of these measures had on the liberal democracy in the system. So it's quite an interesting case. Memory laws, a sort of close cousin in some ways of hate speech laws, are also an interesting example that we go through in some depth in the book. So those are basically laws that criminalize the denial of certain historic acts. The paradigm memory law is a Holocaust denial law, right, which originated in Europe. And then there was a kind of template that was picked up. The EU itself sent out essentially directives or guidelines that you should have, countries should have laws basically prohibiting denial of the Holocaust. Those sorts of laws spread throughout the region. So it's a pretty successful kind of export within Europe and to some degree within other regions. And you see kind of interesting examples of borrowing, both in Eastern Europe and in Russia, right? So in Poland, you have an interesting line. In Russia, both of those kind of copy almost verbatim the basic template that was picked up, but then they add stuff to it. And the stuff they add to it is intended to basically criminalize certain forms of speech that is seen as, potentially problematic for the regime. So you can see that memory law kind of transmute as it gets copied or borrowed across space. A couple of the other examples that we go through in the book, one is looking at courts, the use of militant democracy norms, both in Cambodia and Thailand, to potentially ban kind of opposition parties. Cambodia is a pretty straightforward case, but an interesting one. The opposition almost wins control of the Cambodian legislature in 2013 in a surprise, right? They're still a minority, but they win a huge amount of support. The ruling party turns to the court then in an effort basically to get this opposition party banned. And the court obliges, right? They ban the party using norms that are kind of fascinating. Like they argued, I would say very ironically, that the opposition party was a threat to a plural multi-party democracy. That was part of the ruling. Of course, the effect of the ruling was to completely get rid of the opposition, right? So essentially, in the next election, the ruling party went from being seriously challenged to winning every single seat, right? Because there was substantially no opposition at that point. So militant democracy, the idea that you can ban opposition parties for being contrary to the constitutional order, that's a fairly obvious target for abuse, and you see that in some countries being abused. There's also a more problematic use of that, I think, or more complex use of that in Thailand, which, where basically the parties and followers affiliated with Thaksin are banned over time, or kind of limited over time. It's a more complex case, since Thaksin himself posed a threat to the democratic order. I won't go into that much here, but I think it does show to some degree kind of the limits of the concept that we're trying to draw out in the book, that there are cases that are more difficult than others, right? And where the terrain is going to be murkier, and that has to be the case, right? Given the nature of the variables that we're working with. A final example is, I think, really interesting, also involves courts, is the right to re-election in the unconstitutional constitutional amendment doctrine, particularly in Latin America, where you have a bunch of court decisions basically holding that presidential term limits found in the Constitution are unconstitutional, because they limit the ability of presidents to participate in politics, and they limit the ability of the opposition to vote for whoever they want. And these decisions are invariably issued at the behest of allies of the presidents themselves, and generally by courts that have been captured already, right, by a regime. So what happens is a president gets towards the end of their term, decides they don't want to leave power, and the in vogue way to do this now in Latin America is basically go to court and get the court to get rid of the term limit. There's some fascinating cases involving kind of constituent power. Nicaragua, where Daniel Ortega at that point lacked the votes to amend the Constitution, so went to the court. Court got rid of the term limit. And then some interesting recent ones. There's a decision that came down recently in El Salvador along these lines, right? But there are also very complex cases in Honduras and Bolivia that don't even really use the unconstitutional constitutional amendment doctrine, because in those cases, the term limits were part of the original Constitution. So they sort of developed a doctrine of the unconstitutional Constitution in order to get rid of term limits that were preventing incumbents with authoritarian leanings from running for re-election. And the effects of this re-election in Latin America, I would argue, is pretty clearly not been good. So as shown in the book, basically this is associated with efforts towards authoritarianism. It's kind of a key point in the whole thing, since it's not necessarily that any one term limit configuration is necessary or optimal, but the record of countries that are pure presidential systems with no presidential term limit is invariably quite poor, right? And many of those countries actually came out of this configuration that we look at. Finally, to talk about solutions, we spent the last chapter in a sense on like, what do we do? And I think it's the most difficult part of the book. There's kind of two dimensions. You could focus on constitutional design. Roz and I have kind of a forthcoming project on design, right? So we kind of separated that aspect out. What do you do at the design level of Constitution? Clearly an important question, but we think a bit of a separate question from what we're trying to do in this book, which is more kind of conceptual, right? And so we focus more on response to the level of ideas. We have some thoughts about, how to more effectively monitor at the international level. So we talk about that some in the conclusion. Then we talk quite a bit about kind of norm production or dissemination itself, right? And what kind of norms basically get picked up by actors in the international community. In a sense, thinking that there's a responsibility on us as scholars, as well as courts, constitutional designers, as to both the kinds of norms we disseminate and how we, probably more importantly, how we do it, right? And the most extreme manifestation of the ideas in the book would be some ideas shouldn't exist at all because the risk of abuse is so high. I think that's possible. It's worth discussing. Probably unlikely to be the conclusion very often, right? The more likely conclusion most of the time is sort of how to abuse proof, if that's the right word, or at least reduce the possibility or the likelihood of abuse of a norm. And although that's quite hard, we do think there are ways you can do it. And we point to examples where we think both kind of the international and the transnational community have been kind of blind to those risks, not as aware as they should be of the likelihood of abuse. An example, I think Latin America, the Unconstitutional Constitutional Amendment Doctrine is a really interesting example in that there's this very celebrated case from Colombia of the court stopping a president from getting a third term. And that's a really well-known case. But you look at recent years in the region, by far the most common use of the doctrine has been to allow presidents to run for additional terms by getting rid of term limits. So it's kind of had a perverse effect as currently constituted. And I think it's incumbent on us, as part of a comparative community, to think about the way our ideas are used and the way they are disseminated, essentially. And the third implication, finally, is just, I think probably the most difficult and the one that we're, of necessity kind of least clear on, right? It's kind of what to do about liberal democracy itself, what this book might shine on the crisis that seems to be confronting liberal democratic constitutionalism model. And one of the things I think we say is, this kind of borrowing that we're pointing to in the book, an aspect of democratic erosion, although an important one, is a kind of empty imitation, right, of the phenomenon. In some ways, it shows the brittleness with which liberal democratic ideas themselves can travel, that they can become kind of empty vessels that can be misused. And we think one antidote for that is more open contestation of ideas, right, surrounding liberal democratic constitutionalism, guided, we think, by the idea of the democratic minimum core, right? So what's truly indispensable, what's kind of beyond debate, democracy itself, right? And particularly the kind of core conception of democracy that we use as the yardstick. But we would suggest that everything else, including stuff that would make us uncomfortable as liberal democratic believers in liberal democratic constitutionalism, should be up to some degree for contestation, and that contestation itself would serve as a kind of antidote to the sort of emptiness of the kind of borrowing that we're highlighting in the book. So I'll turn it over now to Roz to conclude.
Thanks, David. I would just add one other site of the focus of borrowing, as well as one of the other possible solutions. Interestingly, to connect back where I started, which was thinking about Stephen's work and influence, one of the doctrines that we do say is it effectively being abusively borrowed in Eastern Europe is political constitutionalism and variants of weak form review. So if PoGen and Stephen are well known for ideas about dialogue, they too are being abusively borrowed in Poland and Hungary in ways that we think are interesting and troubling. And in terms of solutions, another part of the puzzle we think is very simple in theory, hard in practice, which is a form of global legal realism, which is, the World Bank and many other global institutions have spent 20 years trying to build up the rule of law and courts as in some ways immune from criticism. And we think that part of the, abusive borrowing by courts or abusive judicial review is the product of the fact that the international community sometimes knows that courts aren't acting appropriately or legitimately, but feels reluctant to call them out. And if you like, gender was the same in Rwanda. It's a kind of, well, you're not allowed to be anti-gender rights, so of course we're for it. Well, no, you shouldn't be for it if it's authoritarian in effect. And so part of what we're asking for is a more skeptical view of the invocation of liberal democratic doctrines and ideas and theories, which may be seen as, if you like, almost unimpeachable within certain canons and contexts, but which have much more problematic consequences elsewhere. And so that people should be willing to call out the effects of ideas in context in ways that are more critical and more skeptical, even when they are being applied by venerated institutions, including courts. And that we need to be willing, and this is the hard part, to overcome the fear of being called colonialist or, you know, having a double standard in doing that. We have to be willing to say, well, you know, we aspire to do better, but that is not an appropriate usage of the concept or the doctrine or the idea. And so that there's, as much of this is a recognition among scholars and elite practitioners of comparative constitutionalism, that when our ideas are misused or abused, we have a duty to follow up and call it out as a misuse rather than stay silent or feel restrained in our response. But that's enough from us. We're really looking forward to hearing from Stephen and to the broader discussion. And we've noted, Projen, that there are a number of questions in the chat, which no doubt will continue to come in and we'll respond to after the formal beginning part of the workshop is done.
I thank you for summing up 200 pages in 30 minutes. With that, perhaps we can turn the floor to Stephen for his comments.
Thanks, Projen. Thanks to you and Winnie for organizing as well. And I have very fond memories of 2 visits to HKU Faculty of Law. So this is my 3rd, although it's not in person. Thanks to Rosalind David for writing such a terrific, stimulating book, which I'm just delighted to be part of the discussion and celebration of. So it is an incredibly rich book, and it really does develop, you know, your work on various aspects of these topics, and it does so by really, you know, defining, refining, illustrating, you know, the previous work that you've done on this entire phenomenon. I mean, others of us have, you know, thought and written about parts of it, but you're looking at the whole picture, which I think, you know, really is an amazing contribution. I think the range of examples, again, and also the careful dissection of the types of abusive constitutional borrowing, again, is extremely valuable. And I also like the fact that you go beyond the issue of populism, right? Because this issue does go beyond populism. So, you know, it's a terrific book to read. So I just have really, you know, a few thoughts and questions that I had as I read the book. So I'm just going to go over those thoughts. The first was a kind of very general conceptual question, which is that you use liberal democracy, liberal democratic constitutionalism, and constitutional democracy mostly synonymously in the book, although you primarily focus on the first 2, liberal democracy and liberal democratic constitutionalism. So I wonder first whether you do think that they are synonymous, whether we can move from that to constitutional democracy. And also I wonder whether, in the spirit of your suggestion that there might be some concepts that we should reconsider and perhaps even drop, I wonder whether you think that liberalism might come into that category for 2 reasons. One is that when we do talk about liberal democracy, it invites people like Orban to come up with the alternative of different types of democracy and different types of constitutionalism. And secondly, if we are to reconsider liberal democracy, as again you invite us, I think, correctly at the end, does that mean that we get involved in discussion, well, what exactly is liberalism? What does it mean? Is it going to constrain the discussion in ways that we, you know, might really not be helpful? So I kind of throw in that liberalism, you know, might be something that we perhaps should reconsider when we talk about democratic constitutionalism or constitutional democracy or whatever we think the best term is. Relatedly, I was wondering how your focus on abusive constitutional borrowing by would-be authoritarians compares with the focus that other commentators have made on the use of legal forms and legality. You know, is that a significant difference? Is it perhaps the case that kind of more fully authoritarian regimes tend to focus on the forms of law because they do tend to abide by law because law is helpful for them, whereas perhaps, you know, less fully authoritarian regimes or regimes that are moving away from democracy tend to use the forms of liberal democracy because they still purport to be democratic in one way or another for various reasons. So I'm just curious about that different focus of your book. The third thought was about the scope of the book, because you focus very much on constitutional borrowing here. And as you say, borrowing involves kind of appropriation, transfer of ideas, and it's borrowing by, again, authoritarian regimes in ways that undermine the democratic minimum core. But that possibly leaves out some other similar and perhaps equally troubling phenomena that we see around the world. So it leaves out purely internal changes that don't involve borrowing, right, which might also undermine democracy. And it also leaves out what arguably are kind of abusive constitutional changes in legitimate democracies, right? Because, you know, we're seeing in many democracies similar types of changes, right? Whether it's kind of partisan gerrymandering or voter suppression. And so, you know, I wonder whether your exclusion of those types of actions, you know, is kind of deliberate because you're limiting the scope. Whether you think that's a kind of a different kind of phenomenon than the one that you're focusing on, whether you think it's not as problematic. But we are seeing, you know, the kind of democratic backsliding, whatever we call it, I mean, is taking place in what are still democracies, even if they don't yet threaten the democratic minimum core, as well as systems that have already moved away much further from democracy. So it's kind of there's a similarity, and yet your definitions focus very much on borrowing by authoritarian regimes rather than ones that we see in other regimes. Of course, your previous work on abusive judicial review, you know, is extremely interesting and insightful, and again is a kind of a reminder, right, that, you know, the more we empower courts, the more valuable they become, right, for regimes to capture courts. So it's very much a two-edged sword. But you know, what you have to say and the kind of varieties of abusive judicial review and strong and weak, you know, just extremely interesting and part of this, you know, really great kind of refining of the work you're doing. But there again, I wonder if we abusive judicial review again is perhaps not limited to these authoritarian regimes that have captured constitutional courts, because again, you do distinguish abusive judicial review from good faith constitutional interpretation, which might kind of incidentally have some undemocratic consequences. But when you factor in some non-captured courts in kind of still legitimate democracies, where we're seeing a huge amount of politicization of those courts and partisanship on who gets on those courts, again, you know, there's a kind of a similarity in the phenomenon. You know, when those courts are rubber stamping partisan gerrymandering, when they're rubber stamping laws that engage in voter suppression, you know, I wonder whether, you know, that crosses the line in your definition to being abusive judicial review by non-captured courts in what are still more or less democracies. So again, it's about the kind of similarity or distinctness of the phenomenon when we're dealing with authoritarian regimes. Again, your chapter on abusive political constitutionalism, of course, was very interesting to me and again, extremely insightful. I had, again, two thoughts and questions about that chapter. One is what you have to say about Israel. So I think I agree with you when you say that the campaign to insert a general override clause into the basic laws in Israel generally, or the more general rights provision, the basic law on human dignity and liberty, you know, that's not really abusive, right? Because, you know, that at least purports to be, you know, a response to the very powerful Israeli Supreme Court. It's an attempt to kind of prevent judicial supremacy. You know, that really is kind of a form of political constitutionalism. But by contrast, you say that the most recent attempts to insert an override into any judicial review of immunity for Benjamin Netanyahu, that's abusive, right? Because it's an attempt to consolidate his power. But by your definition of abuse, again, I wonder whether one might argue that whether or not chief executives are immune from prosecution while serving in office is something over which there's a great variation, in legitimate democracies. In the United States, right, the leading view is that the president can't be prosecuted while in office. And so it's not clear to me that even if this override did succeed, it could be said really to undermine democracy, or certainly wouldn't be part of the democratic minimum core, right? So although this is an attempt to apply your analysis to what is still a democratic regime, right, which may be taking its first steps towards kind of authoritarianism in some people's view, it's not clear to me that this really should be thought of as an example of abuse, but by your definition. More generally, I was wondering, again, this is against my own interests, as I was reading your chapter and the part where you say that perhaps we should be reconsidering whether certain concepts that we as scholars use should be, if not dropped, carefully considered, because the costs in terms of authoritarian regimes taking them up are greater than the benefits, whether you would include political constitutionalism in that, right? Because, as you say, its benefits are few in the sense that it is mostly a theoretical issue. The distinction between political and legal constitutionalism is mostly a theoretical debate. Very few modern democracies institutionalize political constitutionalism in a significant way, right, compared to legal constitutionalism. But on the other hand, as you say, it's very easily and frequently used by authoritarians to justify their capture of courts in particular, but other institutions. And so, I wonder why political constitutionalism wouldn't be high on the list in a way of democratic concepts that perhaps we should be quite careful about. Finally, towards the very end of the book, you speculate as to whether or not it's a good thing that authoritarians are engaging in abusive constitutional borrowing, are using at least the forms of liberal democracy rather than their more traditional forms of overthrowing democracy. And I think your suggestion is that it is a good thing because it does constrain them to some extent. It does create greater visibility when they are purporting to be acting in a liberal democratic way. There's still a chance of losing elections, right? Orban may lose an election next year, right? So this year, I guess. So I think there are reasons to think it's a good thing. But on the other hand, I think there are some real downsides of the use of abusive constitutional borrowing around the world. One, it might undermine liberal democracy generally, right? To the extent that it's being used in an abusive way, it might further sap, citizens in liberal democracies' faith that this is anything really to celebrate. And perhaps even more specifically, it might result in what could be reverse abusive constitutional borrowing. That's to say, public officials and opposition parties are actually looking at the success of abusive constitutional borrowing in authoritarian regimes, and perhaps they will start to borrow and increase the amount that's taking place in democracies. And so, that kind of reverse borrowing by democratic regimes, by democratic politicians, which of course is always something they have an incentive for, right? People in power in democracies would love to tilt the playground, the playing field in their direction if they can get away with it. We see, again, we're seeing a lot of it in democracies, right? We're seeing it not just in the US, we're seeing it in the United Kingdom, right? Here's an abuse of constitutional rights right now by Boris Johnson's government. They've issued a proposal to amend the Human Rights Act, which purports to be strengthening constitutional rights, whereas it quite clearly is an attempt to undermine constitutional rights. So again, we're seeing abuse of constitutional rights by democracies, and arguably they are copying the playbook of the usual suspects. So that again, I think, is one of the downsides, so that we might actually be better off if authoritarians go back to the more traditional methods, rather than potentially undermine faith in liberal democracy more generally. So I'll end there. It's a kind of a fabulous book, which I'm delighted to be part of the celebration for today.
Thank you, Stephen, for those extensive coverage and insightful questions. I think before we turn to the questions from me and the floor, would Ross and David want to respond somewhat to Stephen's discussions and questions?
That'd be great. Thanks. David, do you want to start? You want me to start?
Sure, yeah, I'll just take a couple minutes. There's so much there. We're very appreciative.
There's a tour de force.
Yeah, no, that was
almost a book review.
Basically, yeah. No, thanks so much for those. Let me just respond to a couple of the points. So the first about what do you do with democratic systems that show these kind of tendencies? And I think, we talk about this some in the more, actually, I think in the Abusive Judicial Review article, maybe, than we ended up doing in the book in some ways, where we talk about the US and whether abusive judicial review is going on in the US, right? And then kind of what forms. And I think, in the book, there's kind of two ways to think about this. One is what we call proto-abuse in the book, which is a phenomenon basically of consolidated democracies doing bad stuff that is not particularly harmful in that context, but that has a demonstration effect. The thing gets picked up. And there's some interesting examples of that in the book. I mean, like the first of these re-election decisions I referred to is actually Costa Rica, I think in 2003. And basically the president, an ex-president of Costa Rica, wants to be reelected, and his party wants him to be reelected. So they issue a decision allowing it, but in a context in which, for various reasons, there's not a lot of harm to the democratic minimum core, unlike these later Latin American cases. And so the main negative effect of the Costa Rican case is that it actually gets cited and used by later actors as justification. And that can be extremely harmful. A case like Costa Rica is so celebrated within the region. It's the home, right, of the Inter-American Court. It has all this kind of legitimacy within the region that's pretty bad. But then the second aspect of this is the difficult question of when, within consolidated democracies, changes actually have an effect on the democratic minimum core, right? And whether so I would stick with our definition. I think it's the right one. But then I think that the line between what one would call consolidated democracies and not, as we know, it seems to be thinner than I think we thought even, certainly a decade ago. And so you take the US Supreme Court and whether it's engaged in a program of abusive judicial review, I think it's very difficult to say, right? There's some aspects that show glimmers of the weak form, refusing to review partisan gerrymandering, no matter how bad. And yet then you look at the counterpoint, which is like, so for example, this round of redistricting after the 2020 census, the Democrats aren't doing that bad, right? There's like more partisan balance. A lot of that's just dumb luck or in like random things happening in different states. But it does suggest it can be kind of hard. It can be hard to know ex ante in some of these cases what's gonna break or really attack the minimum core. And there's a debate going on in the US as to like where's the vulnerability gonna come from if it comes. So there's a lot of concern about the 2024 election, right? As you know, and And yet there's all these questions about, well, what is the vulnerability? So even figuring out a legislative program to kind of combat that is difficult because it's not exactly clear where the threat's going to come from. And that's common, I think, in episodes of democratic erosion. All that said, I guess that's a long-winded way of saying I'm not sure I think there is a threat, right, within these systems. I think the democratic minimum core is useful as a yardstick. But this is one of the problems is that it can be hard ex ante to figure out in close cases, right, what actually is going to damage the democratic minimum core. And that's my fear regarding the US right now. It's not that there's not serious danger to it. It's just not exactly clear by what route the threat will materialize. The other point I wanted to make very quickly is just about liberal democratic constitutionalism, the relationship. I think our answer there would be complex in the sense that we both believe there should be more contestation about things outside of the minimum core. And that means the liberal piece, I think, in part of liberal democratic constitutionalism should be, in some sense, more contestable. On the other hand, I think that it's striking that when you hear actors criticize liberalism, like Orban, they're often trying to do it to claim that they're the real Democrats, right? The liberal democracy is like a farce, but they're not claiming they're not Democrats. Actually, a lot of these kind of populist-leaning actors are arguing they're more democratic because they're like carrying out the majority will. And there, I think, somewhat maybe paradoxically, there's a role to play in pointing out the way that many liberal institutions buttress real democracy, right? In the sense that if you get rid of the checks on power, you pack institutions like constitutional courts, you get rid of term limits, et cetera. It's not, you weaken rights or abuse them. It's not just that you're harming minority groups, although you are, but you also are rigging the electoral playing field farther in favor of the incumbent. And that's also the clearest intent of these kinds of measures. So I think one thing our analysis does elucidate is the relationship between the two pieces, and the fact that often the liberal stuff isn't just there to protect, liberal values, but also to protect the democratic minimum core itself. And without that stuff, it's much harder to have a democracy. So I would like a contestation, but I think for both Roz and I, the end point is likely to be that, at least a good chunk of this stuff is stuff that's really there for good reason, right? To protect the democratic minimum core. And I'll turn it over to Roz.
Thanks, David. Starting there, I think both of us are committed democratic constitutionalists, but also liberal Democrats, as long as one understands liberalism in a capacious and contestable way. And one of the things that we want to highlight in the book is that liberalism and democracy tend to erode together. And so the claim by people like Orban that there's such a thing as illiberal democracy that's real constitutional democracy is a fig leaf and a fiction, and that indeed the core rights that are necessary to the democratic constitutional minimum core are liberal rights and freedoms. And so the two have a much closer connection than the, sort of expedient illiberal democratic discourse would suggest. So I just want to pick up on a couple of the things. One is the sort of scope between, if you like, established democracies at risk and then, those who are well on the way to authoritarianism. And this might come up further in our discussion in the Q&A about local questions and context. The second is about proto-borrowing that David's talked about, proto-abuse, and then reverse borrowing and political constitutionalism, because I'm not ready to give up on it yet, Stephen. So I think the thing we want to suggest in relation to the scope of the phenomenon is that this is not unique to, fully authoritarian or even hybrid regimes, that it can occur in any context. and that sometimes it occurs even in a really established democracy in a way that looks like something that's not borrowing, but often it has a sort of long distant borrowing origin because it's drawing on sedimented practice within the system that has liberal democratic origins. And so that there's a difference between inspiration and justification. So if you take David's, original piece on abusive constitutionalism, invoking an amendment procedure by itself invokes a claim to democratic legitimacy, and sometimes in ways that erode democracy. And so that sometimes, if you like, the borrowing is very ancient and sedimented, but it's still in the background. But of course, this book is not about everything that has, a number of people generously have said, this book covers a lot of terrain. It doesn't try and cover the whole terrain. It's only about some part of the problem. And the extent to which people are using sort of long sedimented norms that come from prior understandings of liberal democracy, that really is at the margins of the phenomenon. But it's not completely different in kind because it's still invoking the same form of legitimacy, which is an abuse of the legitimacy associated with liberal, democratic or democratic constitutional designs and choices. The second point is about proto-abuse. So David talks about the demonstration effect. The other way of thinking about it might be about what is the first step along a continuum of behaviour by which at the end we can confidently say there is abuse. And that looking at the first step, it's very hard to know how it plays out. Whereas by the time we get to the end, we know how the story ends, and therefore we can look back and go, that was the first step. And when we use the word proto-abuse, we often mean this is the first step along what could be a pretty clear continuum toward full abuse, although we're not confident how it's going to play out. And I think it's fair to say that Israel remains in dispute as to where it is at, and that the original debate around a kind of override was really probably legitimate, and the debate around kind of immunizing Netanyahu in the specific instances seemed to us to be on the kind of way toward a more abusive pattern. But of course, as you note, Stephen, the same kinds of behaviours can be found in some other contexts. It really does have to be pretty granular because there may be a difference, for instance, between executive immunity behind the veil of ignorance versus giving it to yourself, right? So there was a pretty strong view in the United States that if President Trump was to pardon himself in advance, that would be different in kind to the ordinary use of a presidential pardon. Similarly, for midstream, while a corruption and criminal investigation is being pursued, for Netanyahu to try and impose a change that gives himself immunity would have a different quality to a generalised law giving the executive immunity. So one of the difficulties with early stage, abuse is it's really hard to know how it ends, and it's very difficult to confidently predict that it ends poorly. And so one can call it out, but call it out tentatively as concerning, potentially abusive, proto-abusive, etc. So, for instance, Boris Johnson's prorogation of Parliament was clearly proto-abusive, but the court stepped in. The Johnson government abided by the decision. It pulled back. And there are a number of instances of pullback. And our ideology, our perspective, will make us take different views. So, for instance, David and I routinely have disagreements with Mark Tushnet about Venezuela. And, he has a much more benign view of Chavez than we do. And yet he would agree that Maduro has crossed the line to abusive constitutional change. And so, we would be willing to call out abusive change earlier in Venezuela. Mark's only willing to call it out kind of in the Maduro period. And again, that continuum is a contestable one, but we're pretty confident that you would notice things early on, which you'd say, oh, this could be abusive, proto-abusive, this requires a much closer watching brief. But to your question about how that relates to the US and hyperpartisanship, we want to be absolutely clear that lots of bad stuff that's hyperpartisan, anti-democratic can happen in a way that doesn't yet meet the threshold of abusive in our sense because it doesn't affect the democratic minimum core. So Bush v. Gore, terrible decision, probably not abusive in our sense, and at most proto-abusive because it didn't adversely affect the democratic minimum core or could, be argued not to. So I think early stage, yes, but not unless it has some meaningful potential to undermine the democratic minimum court. Although hyperpartisanship and polarization is clearly in its own right a threat to democracy, conceived of as a broader set of reciprocal norms that involve cooperation and restraint in the sort of Levitsky and Ziblatt sense. In terms of reverse borrowing, I think you're absolutely right, Stephen, and that one of the things I think we want to say in the book is this, and we say right at the end, this should worry people sitting in Washington and London and Hong Kong and Sydney who are committed to constitutional democracy. Because the more the discourse that you prize is degraded, the less it means both abroad and at home. And it would be much better in many ways for would-be authoritarian actors to do it much more openly, brutally and instrumentally, not in terms of the loss of life, but in terms of the instrumentality of it, than to pretend that they were maintaining the veneer of liberal democracy without its substance. Because A, they make it harder for us to challenge and contest, but B, they degrade the thing that has been exported, and the reverse importation of a kind of degraded, cynical vocabulary of the kind you mentioned in relation to the, strengthening human rights in Britain is absolutely classic. And we say something at the end of the book about how the degradation in language in liberal democracy itself may be part of the root cause, which is if management speak and McKinsey speak, where people know that people are misusing language in speaking about change, is something we come to be accustomed to, well, then both abuse and reverse importation of abuse is not, something that should surprise us. So, is political constitutionalism one of the doctrines that we think, should be defined out of the canon? No. I mean, we're all committed, weak, strong review people here, and we maintain that. But I think what it does say is that in developing a theory, and, you could say that your own work was on the sort of more defensible end of this, Stephen, that one needs to be much more explicit about the preconditions under which it is desirable or attractive. So the short piece that Mark Tushnet and I wrote about weak form review in Asia, where we say, ironically, weak form review is most attractive and yet also most likely and yet most unattractive under conditions of dominant party democracy. And that really, for it to be a normatively attractive theory, it needs to have political competition as a necessary condition. To me, that's a particularization of the theory that is a deeply important particularization that can't be a footnote. So that when one develops theories, it's not an on-off, like maybe we should never have come up with it. It's that when we develop it, we have to develop it with abuse in mind. And that means that, Jeremy Waldron needs to stipulate his conditions much more carefully with abuse in mind, and, as do the rest of us. So we're not ready to give up on political constitutionalism, but rather to say that when we develop, we also need to particularize with that in mind. As to autocratic legalism, I mean, we say very openly in the book, we're all doing something similar here, right? This is not something that no one else has thought of. This is an elaboration of important ideas by Kim Lane Shepley and, Ozan Varel and Alvin Chung and others. But we do think it's important to note that legalism is different from liberal legalism, if you like, that there's something about the presumptive legitimacy of democratic constitutional ideas that bring with them a sort of weight of presumed legitimacy that is even stronger than law per se. So dictators have always used law, right? But they've used it often in a very instrumental sense, right? Did you breach the law? Yes, go to jail. Not the kind of ideas that we're talking about. And that we think that there's something particular to the sort of democratic constitutional form of law that brings with it this presumption, especially internationally, of legitimacy that's very debilitating for attempts to oppose and constrain it. So it's very much a cousin of those ideas, very much owes a debt to those ideas that we make very explicit, but we do believe there's something different when the law carries with it presumptive constitutional legitimacy. Thank you, Pojen.
Thank you, everyone, for that exciting and invigorating discussion. We'll now turn to the Q&A.